these copyright, goodwill, patent, know-how, business relations. So there are a number of rights, a number of intellectual property that are well established, and there are a number of things that will evolve with time. Okay, for instance, know-how, business relation, research and development, traditional knowledge, trade secret, and traditional culture. And so many things come under soft IP. Okay, by soft IP, what I'm trying to say that intellectual property, depending upon their nature, can be categorized into two parts. One is industrial property, and the other is non-industrial property. So industrial property is that kind of property which is basically applied to industry. Okay, for instance, trademark, patents, designs, which have some role to play or which have a utilitarian objective as far as industry is concerned. There are certain non-industrial properties such as copyright. Copyright is more about creativity or artistic work. Okay, so if you compare industrial property with non-industrial property, then economic aspect plays an important role as far as industrial property is concerned. But if you talk about non-industrial property like copyright and neighboring rights, the focus of legislation is more on protecting the rights of artists or creative people. I'm sure you all will agree with me that what is the new wealth? Certainly, it is not the land or property, it is the intellectual property that a particular industry possesses. So I wish to, or I would substantiate this statement by giving you certain facts and figures. So these are the companies which feature in the top 50, or they possess a lot of brand value. Okay, I've taken this data from the Forbes. So if you look at Microsoft, Apple, Google, Facebook, McDonald's, Disney, Netflix, these all have a very strong brand value. And they have a very strong brand value for the reason that they all are IP intensive industries. IP intensive industries meaning thereby that they hold a lot of IP, be it technology, be it media, be it designs. Say, for instance, if I have to talk about Coca-Cola. So Coca-Cola have a very strong presence as far as their brand is concerned. Trade secret, designs, their trademark. You talk about Apple. They have a lot of patents. They have thousands of patents as far as their technology is concerned. You talk about ESPN. ESPN, they have broadcasting rights. So this is something that comes under copyright. BMW. BMW comes under automobile. So they fall under patents. They have designs as well. And there are a lot of licensing and other kind of agreements that gives or gets them a lot of economic benefit. So all these companies that you see on your screen, these are IP intensive companies, and they make a lot of money because of their rich intellectual portfolio. And this is what this slide is all about, that how did they all become so rich? What did they all do? So if you look at these companies, they're either automobile or data-centric companies or beverages or media companies, clothing, apparel. So they all deal with some kind of strong IP, and with that, they have made a very good reputation in the market, and that is what their brand value is. In case you have a question, please, you can put the question in the chat box if that is an option. I hope I am audible to everyone.
Yes, ma'am. Yes, ma'am.
Okay. Right. Okay. Now let us understand individually what trademark means, what copyright means, or what is patent, what is industrial design, and then we move on to the socio-economic aspect of these intellectual property rights. This is a very interesting example because in one slide you get to know what all IP a single product can have. So for instance, if you have a phone or a mobile phone or anything, the logo that you see is basically its trademark. I'll explain what trademark is. The patent is basically the technology that is used in the phone. The phone design is something that comes under industrial design or patent design. Then copyright is something that if it has a software code or the instructional manual, that is something that comes under copyright. Then you have trade secret and technical know-how. This is something which is soft IP and not published, which is protected by confidential agreements and all. So a single product can have several IPs, as you can see from this particular slide. And there can be other examples as well. Take, for instance, a washing machine or an automobile or a car, anything. A single product can have multiple IPs, and that's what generates a lot of brand value to a particular company. Now let us understand what trademark is. I'm sure you all have a knowledge about what trademark is. Either you have studied IP, or even if you have not studied IP, then also I'm sure you know what trademark is. It is something that is, everyone knows it is a brand. It is a brand in relation to a particular product. So trademark, I would say it is a very strong advertising mechanism or an advertising tool. Okay. And this tool, you make yourself or you make your product known to the world. So it is a strong advertising tool. It has to be something which is distinctive. It will have goodwill over a period of time if you market it well. Look at these examples: Yahoo, Samsung, Netflix, BMW, McDonald's, Ford, etc. So a trademark is something that identifies a particular source. Okay. If we go a little, in the history, then earlier the mark was seen as a source of liability, meaning thereby when the evolution of understanding the mark was going on, that why do you actually put a mark? Why do you need a mark? So earlier people used to put mark to show that you own a particular thing. Okay, so if I put a symbol, a seal on a particular product, then it used to signify to other people that this thing or this package belongs to a particular person. And then it became a source of liability, that if the product is not of a particular standard, then that person can be held liable. But eventually it became a source of identification. Okay, so from source of liability, it became a source of identification, that you identify a particular product with a particular company. And that is how you associate some kind of reputation with a particular mark. So for a consumer, trademark is all about, you can say, if you ask me the modern understanding of what a trademark is, it is not just a source identifier. It is something that talks about reputation. I associate a particular reputation with a particular mark, okay, or with a particular brand. So if you ask me about my personal choices as to which brand do you like as far as apparels are concerned or sportswear are concerned, definitely each one of you will have your own choices. Okay, that you either like Nike or Adidas or Decathlon or so on. Similarly, if I ask you, do you have a personal choice as far as perfumes are concerned? You will have your own choices if you have used a particular brand. Okay, so trademark is something that helps you to identify a particular product, and if you have used it, then that company builds a reputation in the market. So if that company wants to expand its business and go into some other kind of product as well, as a consumer, you will assume that the other product will also be good because this company is good. So that is what the trademark, or that is what the brand or the goodwill is of a particular company. So however, the mark can be anything. If you look at the latest example, that even a smell mark can be a mark. So if you smell something and you identify a source, it can be a mark. The sound mark are the latest. A lot of registrations are being given on sound marks. Like one of the earliest example of sound mark was Yahoo Util or Nokia ka ringtone, or ting 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 Britannia ka. So if you identify a particular company with a mark, then that becomes a trademark. So anything under the sun can be a trademark. It need not to be a logo always. It can be smell, touch, shape, packaging of a particular product. Anything can be a trademark. I hope there are no questions as of now. Yes, Krishna, are you there?
Yes.
Hello.
Hello. Yes.
Hello. Yes, ma'am. Anybody has any doubt, they can ask as of now.
Okay. Anyways, so just let me know if there is a question. Right.
Okay, ma'am. Thank you so much, ma'am, for your brief discussion about trademark and copyrights and everything. Moving further, we have the second speaker, Mr. Krishnan Goyam, sir.
There are a few things left, and then I'll hand over to Krishna.
Okay, sure, ma'am, sure.
Okay, right. So, are the slides visible?
Yes, ma'am.
Yes, okay. So now talking about copyright, copyright is something that protects the creative aspect of a society, be it literary, that are books, sound recording, musical, dramatic work, artistic, cinematographic films, the songs that you listen, the books that you read, drama, anything that is something artistic in nature, creative in nature, that is something that is protected under copyright. So you paint a picture, I'm sure many of the listeners कोई पेंट करता होगा या कोई पोएम लिखता होगा या कोई गाता होगा, all those kind of creative things are protected under copyright law. Then we have geographical indications. Geographical indications is a very important IP as far as socio aspect of IP is concerned. It is something that belongs to community. Okay, not just geographical indication. If you talk about traditional knowledge as well, so geographical indication is given over product which belongs to a particular geography or particular region. For instance, Darjeeling tea, or Nagpur ka santra, or Madhubani painting, or Kashmir ka saffron, blue pottery. So all these products will have some feature because of a particular region. It may be climate, it may be soil, it may be a particular temperature at which the goods are manufactured. So any product which is agricultural, horticultural, natural product, or manufactured product can come under geographical indication, and the rights belong to community. So identifying a particular product as a GI basically identifies a particular community, that this is the region which is known for this particular product, and that basically impacts the socio and economic condition of a particular region, because this GI tag gives them a recognition in a market in relation to a niche product. So with identification of a GI tag, or with when their product is certified as a GI, then it gives them a recognition, and that uplifts their socio and economic condition in the market, in the nation or worldwide. Then talking about automobile designing is again a big game. It involves a lot of money and a lot of disputes as well. So designing is something, uh, for instance, you look at this car, जो कार का design है या phone का जो design है, shape है, configuration है, या ये bottles पे जो design है, or these fashion designing, or these apparels or jewelry or accessory. So whatever is appealing to the eye in terms of a design of a particular product is something that can come under that is protected under industrial designs. Now, talking about the role of lawyers, that what is the role of lawyers in trademark, copyright, or industrial design, or geographical indications? Well, right from the beginning, right from the registration till filing the disputes in the court of law, lawyers have a very important role to play. So when, for instance, if I talk about trademark, so if you want to know as a startup whether your mark is capable of being registered as a trademark or not, it is the lawyer who can give you a legal advice as to whether you should go ahead with a particular mark or not. I see a lot of logo in the market which I think cannot be registered as a mark. Why? Because as per law, they are either generic or they are either something that belongs to common pool. Okay, so before coming up with a particular logo, I think you should have your research, you should do your research well, and then only come up with the logo. So for that purpose, if you have, consult or take advice of a particular IP lawyer, then it makes more sense, and then you will have a surety that your particular mark will be protected in case any dispute arises in the future. Not just registration, but also in case of drafting. So be it copyright drafting, license agreement, कोई आपको music किसी और को देना है assignment के through, or as far as trademark is concerned, कोई franchisee agreement है, McDonald's को किसी और country में they have to set up their business, or they have to open their store. For all these purposes, you need to have an agreement, and an agreement effectively can only be drafted by a person who understands ins and outs of IP. Okay. The third part is litigation. If there is any dispute, if there is any violation of the rights, then you go to court. and then you file a dispute. And this again can be done by only a person who understands intellectual property rights. So one who specializes in IP becomes, he understands the intricacies of IP, and he can give a very effective advice as far as the remedies are concerned, or filing of a particular trademark or copyright or industrial design is concerned. I think this is pretty much as far as the briefing of the IPs are concerned. Now I would like to request Krishnam to take over from patents.
Thank
Yes.
Ma'am, we have a doubt from Anmol Parekh.
Okay.
His question is, can we register that particular sound under sound mark or copyright or under both?
No. Sound, okay. So what you're trying to say is sound as a musical composition under copyright and sound as a mark under trademark, right? It can
Yes,
fall
ma'am.
under both. If it is a musical composition, ठीक है, if it is a musical composition, कुछ इसमें rhythm है या कुछ lyrics है और वो कोई composition है, then it can be registered as a musical work under copyright, and it can be used as a sound mark as well. But the difference lies in the fact that what are the legal requirements? Okay? So as far as trademark is concerned, your sound mark has to be distinctive in nature. Okay, it may be a musical composition, okay, but it has to be distinctive. Distinctive का मतलब हुआ that the consumer or the potential consumer, they identify the sound with the company. Okay, so if that has happened, then it is more likely that you will get your sound mark registered as a mark. But as far as copyright is concerned, it will look into whether your sound, जो आपका sound है, जो जिसको हम musical composition बोलेंगे, अगर आप copyright के लिए जा रहे हैं, then it has to be original. Okay. So see, as far as sound marks are concerned, I would say there is no conflict here. Okay. The question usually arises in case there is a conflict. For instance, the conflict will arise between copyright and designs law. कि कोई artistic work है तो वो copyright में जाएगा या फिर वो designs law में जाएगा. Okay. Similarly, a conflict can arise whether a shape can be a trademark, but what if a shape has a function as well? Then should it be trademarked or should it go under patents? Okay. So जब conflict होता है दो rights में, then only this issue arises. If there is no conflict, then a particular thing can fall under both the legislations. And moreover, copyright registration is not required. Okay. The moment you create it, you have your copyright over it. ओके तो अगर आपको लग रहा है जो आपने साउंड बनाया है जैसे जिंगल्स हो गए राइट जो एडवर्टीजमेंट में जिंगल्स बनते हैं सो दे आर म्यूजिकल वर्क the moment you create it you have copyright over it, and if you want to go ahead with the same jingle as your sound mark, then you will have to prove that people identify the product with the jingle, and that is why you are claiming sound mark over a particular jingle. I hope that satisfies the question.
Ma'am, there is one more query from Mr. Nilesh Kumar. Will
Yeah.
passing of be allowed to unregistered trademark which are generic in nature?
Passing off be allowed for unregistered trademark which are generic in nature? See, I understood the first part of the question, but generic, I will need more facts from you. But yes, passing off is a remedy that is available to a product which is, or to a company which has registered its trademark or they have not registered its trademark. Okay? So passing off इसीलिए remedy है. Even if you're not registered, then also you have a remedy. And that is what passing off is. Okay?
Thank you, ma'am.
Yes. So Krishnam, would you like to go ahead from patents?
Yes, ma'am. Thank you so much, ma'am, for briefing us about the intellectual property rights in terms of trademarks and copyright. Second speaker, we have Mr. Krishnam Goyal, sir. He is an engineer, advocate, and a patent agent who worked for 3 years as patent attorney in India. He has completed his BTech LLB from UPS Dehradun and is currently pursuing his LLM from Munich Intellectual Property Center, Germany. He'll be discussing about socio-economic importance of patents and role of lawyers or patent attorney in IPR. So please welcome.
Thank you very much, Nalini, and thank you very much Charu, for a wonderful presentation on other IPs. Now I'll be taking forward on the patents. I hope my voice is audible to everyone.
Yes, sir.
Okay, great. So as we all know that patents are given over a technology which is new, novel, and which has some industrial application. So now when we talk about the patents, it is like any other IP right. It's a negative right. So there's always a conflict whether when someone is filing for a patent, does he want to use that patent for his own invention to be used by himself, or he wants to he wants to exclude others. So one thing that we really need to we need to understand that patents are granted as a right to exclude others from using, selling, importing, and exporting the product of your own invention. Now, there's one very particular thing about patents, that it has a major impact on the social and economic development of a country. And that is the reason that the patent law itself, under Section 83 of the Act, engraves the social and economic objectives of the Act. So we'll read Section 83, subsection 1, the first point, which says that to encourage innovation. Now, one of the primary objective of the patent law was to encourage innovations. I'm sure at the time of the drafting of this Patent Act, the lawmakers were confident that patents would have a very major impact on the GDP of the country, and hence it can have both the social and economic aspects. So the first part, which is to encourage innovations, we'll see that it is when there is an innovation, our life becomes more comfortable. We adopt more modern ways of living. We adopt more standards of having a better life, and that is one of the reason why USA is so ahead of us. They have created a environment, a culture of innovation. However, India lags behind. We'll be discussing the statistics ahead in the slides. But the major basic objectives of the patent law is to encourage innovation so that we can have some social development as well as economic aspects. Now, we'll read the first point in connection with the third point. The third point says that the patent application and the patent holder should disclose the full, complete information about the invention. Why is that so? Because when the patent rights are expired, the public can make use of those inventions and they can further improve that technology into a new one, a more efficient one. And also, during the term of the patent, there is a ground of defense, that defense of infringement, that a patent holder would not be given an infringement damages if someone is using his invention for research and experimentation. So that is the case whenever we talk about drug market. We have generic producers. We have generic producers who are always doing research on the patented drugs, so that as soon as the term of the patent gets over, the generic producers can get their products into the market without wasting any time. So to encourage innovation and to encourage research and innovation, research and development culture, there are some objectives which are point 1 and 3. Now, talking about the economic aspect of the patent law, you will read point number 2, which is to ensure that the patents are worked in India on a commercial scale. Now, when we say the worked in India, it means that whoever is the patent holder, he has to ensure that the patented product or a technology is developed or it is manufactured in India, so that we can create some employment opportunities. We can have some resources. We can adapt to a culture wherein we can improve our skills, and that is the reason that it is a requirement that the patent should work on a commercial scale. To ensure this, that the patented product is not only imported, there is point 4, which says the patent should not be used only as a tool for monopoly, as the exclusive importer. So you cannot, if you have a patent, you cannot just go to the other country like US and start developing products over there and then start selling it in India. It is an important requirement that the patented product is developed and created in India. So whenever the patented product is developed and you have a manufacturing facility, there are more options of creating trade between between the different countries. There is an improvement in the economy, and hence this is the major role of patents. to improve the socio-economic development of the country. Now we will talk about the role of the lawyers, patent attorneys, or the patent agents. Charu, could you please move
Yeah.
the slide to the next one? Thank you. Now, this is one of the case studies wherein I'll tell you how important the role of the advocates or the patent agents or the attorneys are. As you all know, that a patent application can be drafted and filed by an applicant who's a natural person for himself, or it has to be filed by a or drafted by a patent agent. Now, in this particular case, there was a applicant who was a natural person, and he was about to start his new company as a startup. Now, as we all know that startups are very have limitation of funds, so he thought, okay, let's not put a lot of money with the patent attorneys in their fees or in taking their services. Let's draft it by ourselves and file it at the patent office. So the picture that you will see under the text of over the text of before, this is what the patent holder or the applicant filed for the first time. However, there are some rules and regulation and standards of drafting a patent application which are accepted worldwide, and without which, if your application is not structured properly as per the standards of the patent office, your application will be rejected. So just imagine if there's an invention which is terrifically important for the improvement of the socio-economic development of the country, and it has a lot of benefits, and that invention, if not drafted properly, will be rejected. So it could have a loss of there could be a lot of loss of economy as well, not just the rights of the patent holder or the inventor rights. So luckily this person was suggested and was informed by one of the fine gentlemen that since your invention is very important and it looks very novel and inventive, you should consult a patent attorney so that he can take the process further. Luckily, the patent application did not cross the term of 12 months, and he came to us. So what we did, we just drafted this patent application in a more standard form. You will see the after picture, which I've put it on the right hand side. So just see how the patent applications are drafted and how the drawings are drafted. It just converted that solar uh, dustbin into something else, which is not actually understandable by a layman person, but of course it is for the engineers and the public to understand. Similarly, can you move to the next slide, please? Yes. Similarly, the patent application, there's a complete standards and guidelines for drafting a patent application. So what this patent holder did, he just drafted one-page application which has abstract description and claims. However, this is not the way we draft, and hence the patent attorney completely transformed this application into a particular method of drafting, and that's how the claim, the first independent claim, which is the essential claim of the patent application, is was filed. So you'll see there's so much of difference, and at the last, this application was granted. So just imagine how brutally this patent application could have, the patent inventor could have lost his rights if he has not consulted the patent attorney. Therefore, the patent attorneys or the advocates or the patent agents have a very large role to play in this. Whenever there's a invention or there's a technology that needs to be drafted and filed for a patent protection. Now, the next big thing we'll talk about is artificial intelligence. We all understand the terrific and the tremendous effect that the artificial intelligence has on the social and economic aspects of the country. Just to give you a little insight about it, you all know how these these Apple watches work. So there was a person, I think it's a case happened in USA, wherein he fell from a cycle, and the Apple Watch automatically gave a signal to the hospital, and they could come on time and they can give him a first aid. However, if he was not wearing this Apple Watch, there could have been a loss of his life. So I would say that artificial intelligence could be placed over and above the drug industry as well, because precaution is always better than the cure. And hence, but the problem today in the patent framework is that the artificial intelligence is not protectable under the patents or under any other IP. And there is a case, very famous case of Dabus, wherein the patent holder, I mean the patent applicant, he filed the application before USPTO, before European Patent Office, before other patent offices, and he named a machine, Dabus, as the inventor. However, a machine cannot be named as an inventor as per the current patent laws. But as we understand that artificial intelligence has a role to play in improving the social and economic aspects of the country, and it should be included in the patent law. Therefore, the advocates, the patent agents, and the patent attorneys, maybe in India, would have a bigger and a very larger role to play when it will come to advocate the rights of a machine as an artificial intelligence. As of now, the machines are not protected. However, whenever there's a case of something like this come in future, the advocate and the patent agents, patent attorneys would have a very impactful role to play in granting the rights to AI machines. Well, do you have any questions meanwhile? Okay, so there's a question by Mr. Justin. Who will be the patent?
Who will be the patent holder in the case of AI invention? This is a question posted by Jaswant Sairam.
Okay, so to be honest, right now there is too much of uncertainty. There is no clear guidelines whether invention created by AI could even get a patent. So patent holder could be the person who is investing a money in it. However, who is the patent inventor? The inventor of the invention, that invention, it is not clear. And the invention, the patent holder is given right by the inventor. So when we do not have clarity in who is the inventor, we cannot say who will be the patent holder, and hence right now there is no certainty. But as per the decisions of the EPO and the guidelines issued by the US, we can say that AI machines are not patent. AI machines as an inventors are not protectable under the patent law. What is the extent of India in granting the patents to software? Okay, now when it comes to software, there is again a very strict guidelines that India follow. Software per se under Section 3K of the Patent Act 1970 is not patentable. However, if there is some physical interaction happening between the software and hardware, which is going beyond the normal interaction, and there are some some real world problem which is solved by that software having some contribution of the hardware, then it can be patented in India. But right now it all comes out to who is the patent attorney and how wisely he is arguing the case, because the stand of patent office in India is very strict and they do not want to grant a patent to a software. However, if it is argued in a very wise manner, a patent invention having a software aspect to it can be patented. I hope it answers.
And in addition to what Krishnam said about rights over software, so as per copyright law, programming comes under Indian Copyright Act of 1957. So it is protected as literary work, as far as the coding is concerned.
I mean, yeah, the source code you can protect it under the Copyright Act. However, the functioning of that source code, it's not certain whether you will definitely get a patent over it or not. It comes about the argumentation and how strong your case is.
Right, exactly. Okay, now, so I believe it's time to move on to the second part of the webinar, which is what is the socio-economic impact of IPR? I think Krishnam has very well explained the socio-economic importance of patents. Now, in this part, I'll deal with a couple of facts and figures which will make things a little clear as far as what is the relationship between IPR and economy. But before starting, yes?
Sorry to interrupt you, but I guess we should entertain one more doubt for Krishnam, sir.
Sure. Yes, exactly.
Mr. Anmol has asked a question. Sir, can you answer his question?
Yeah, I'll just read it out. What if an application has been filed in the name of AI, so the subject matter has been disclosed?
Sir,
Can
sorry, this question is posted by Vidushi. Before that, there is another question.
okay. So with regard to issue of monopoly, whether the patent law is in conflict with the competition law. Okay. Well, yeah. Well, when we talk about the competition law, it is not in conflict as such, because if you have a monopoly over the patent because of the patent, it is not a conflict under any law, because even having a monopoly or a dominance is not a conflict, is not a disputed matter under the competition law. But what is the disputed thing is if that monopoly or the dominance is abused by that company. So abuse of dominance could be a dispute, but having a monopoly or the exclusive rights over a patent is not a conflict as such.
Right. And I think there's a misconception when people say that there is, IP creates monopoly. It does not, because eventually, after a period of time, the invention comes into public domain. So as far as an invention is concerned, after 20 years, it will be in public domain. And as I said in my part, that IP is something that becomes obsolete over a period of time. So even if your rights are protected for 20 years, but your invention might become obsolete after 5 years, there's something better that might come up. So, as far as monopoly is concerned, it is not right to say, that all IP or there is always a conflict between IP and competition law. So, is that all, or there are more
There
questions?
is one more question by Ms. Vidushi. What if an application has been filed in the name of AI, so the subject matter has been disclosed? Can the application then be filed again, incorporating that previously disclosed matter, but now in the name of natural person?
Okay. Well, I understand when you say that an application has been filed in the name of in AI, you mean to say that that the inventor is AI, right? Okay, so assuming that you mean to say that the inventor is AI in a particular application, and so see, when you are disclosing your application, your invention, and you want to change the name of the person or inventor, you have a provision to file amendments, and that is very much acceptable. However, if you have filed an application and you don't change the name of the inventor, and you then file another application, then your previous application will act as a prior art, and you will not. I mean, your application having a natural person will not be considered as novel or inventive over those prior arts. And hence, whenever such confusion comes, it is advisable to use the amendment sections under the Patent Act and file for an amendment for the name of the or the designation of the inventor. However, I'm a little skeptical about it because when it comes about the filing amendments, there is no option on the Patent Office website wherein you can change the designation, because right now, as usually it is inventor who's a natural person, it is considered, and hence there is no option to to change it to an AI machine.
Right.
I hope it answers your question. Thank you.
I think it does.
Yes,
Should we
ma'am.
move ahead?
Yes, ma'am.
Are there more questions?
No, ma'am.
Okay, so let's move on quickly to the next part of the webinar, because almost the time is left. We have only a few minutes. Okay, so now talking about the social aspect of IPR, I think Krishnam has rightly pointed out, as far as patents is concerned, that uh, talk about generic medicines or disclosure, all these things sum up the social importance or knowing about intellectual property or using a particular intellectual property. Now, talking about trademark, if I have to talk about trademark specifically, then trademark does have a lot of positive social impact. Like it tells the consumer which product to go for, what is the reputation of a particular product, how can you use a particular product. But it does have a particular, you can say, to some extent, some negative impact. And I want to highlight this point because this is relatively an unexplored area. So while I was doing my research, I could not found many empirical research where someone has done, covered statistics that this is how trademark affects a particular person or a particular society. But by and large, the social impact of trademark can be seen negatively. For instance, it makes a social status, it makes a social divide. So all those people who cater to a particular expensive brand, they belong to a different section of society, and all those person who cannot afford a particular brand, they are seen as a different group. So this is one interesting paper that I read, which reads as "Vulnerable Consumers: The Social Impact of Branding on Children." So this paper is specifically about what is the impact of trademark on teens. Okay, जो बच्चे होते हैं उन पे क्या effect होता है. So one uh, thing that I wish to quote from this paper is brands can be the cause of social division amongst children, resulting in the formation of ins groups and out groups. And I'm sure you all will agree with me because when you look at a particular brand, you form a particular image. So if you look at a particular person wearing a highly expensive watch or highly expensive clothes, you have some kind of judgment or opinion regarding a particular person because you have you look at a particular brand in a particular perspective. And if you look at a particular local brand or a regional brand, you look at it from a different angle, or you have certain preconceived notions about a particular brand. So this is something, but I'm sure it does not affect as far as adults are concerned. But if you look at the children, then trademark does affect their perception regarding a particular society, depending upon the brands that you use. The other impact that is relevant or that people should talk about is brand consciousness. That we all have become so brand consciousness that without trying to know about a feature of a particular brand, we want to use it. So if I ask you that what are those features that make uh, iPhone different from other phones? I'm sure only few of you will be able to highlight those features. But by and large, most of the people wish to have an iPhone because that is something seen as an epitome of reputation or a brand. Okay. Third, with social impact, which is associated with the other two, is the peer pressure, which is again, I'm sure you have understood. So I wanted to highlight this because again, this is an unexplored area, and if someone wishes to go ahead or do some research or empirical research, it would be very interesting to see what conclusion do you draw from that particular research. Now, other important thing which helps you or IPR helps you to understand regarding the society is that how society has evolved over a period of time. So if you look at human civilization, it has definitely evolved through advancement of innovation and creativity. One of the best way to understand a particular society is to look at what objects they developed and what did they actually use. Okay, just a Roman bath or Grecian urn. So looking at the objects that a particular society uses, you can decipher a lot about the culture and a social perspective of a particular society. And moreover, look at the life that we lead now. Our life is dependent upon all the advanced technology or gadgets that exist. Imagine your life without a mobile phone, or imagine your life without electricity or a bulb or elevators, or there's so many things that our life is dependent upon. So this is what is the social impact of technology or creativity or innovation is. Or look at the situation right down lockdown. We all are dependent upon music, books, cinematographic, movie, etc. Imagine your life without books, without movies, without music. And artistic work is something that binds the society. That is also a very important or positive impact of copyright. Okay, that it binds the society, it makes a society full of artistic work or creativity. That are other social angles of IPR. Now talking about the economic aspect, which is a very important aspect of or impact of IPR as far as the GDP or the economic condition of a particular country is concerned. So there are a couple of interesting reports that have come up or that come regularly. For instance, US Chamber in the year 2020 itself, they came up with International IP Index, wherein they compare different jurisdictions on some indicators. Okay, so they take different economies and they compare these economies based on their performance in different sectors. And IP is one of the important indicator which assesses the performance of a particular economy. So by reading these reports, you can easily decipher that IP has a very important role as far as performance of a particular economy is concerned. Okay, you look at the top innovative countries like Switzerland, Sweden, or US. They all are doing very good and very good in research and development and innovation is concerned. But if you look at the other economies like lower income economies or middle income economies, India falls under lower income economies as far as this report is concerned. So we are doing okay as far as our Central Asia or Asia is concerned, but globally we are not doing that great. So let us look at where do we stand in the ranking and how does it, what is the relationship between IPR and economy. Okay, so look at these charts. We have made a comparison between US and China. So if you look at the patent, the filings, and you look at patent filing, trademark filing of US and industrial design, it is increasing with years. Like specifically, if you look at 2015 data of US, 16, 17, 18, it is increasing. And consequently, the GDP or the contribution of intellectual property in the GDP is also increasing. Look at China, the below graph. Again, 2015, 16, 17, 18. Their patent filing is has increased by leaps and bounds if you compare patent filing of China with patent filing of US. And consequently, their GDP has also increased. It has gone more than, it has contributed more than even in US. US is definitely one of the established economies in the world, but China is will be, or it is one of the uh, aspiring economies of the world apart from India as well, because a lot of reports says that India is also going to be a very big economy in the later or in the coming years. So this is how the patent filing or trademark filing impacts the GDP of a particular country. Okay. Now look at this interesting report which talks about employment, that how much employment is generated by IP intensive industries. So there is this report by OECD which says in the long run, innovation and employment creation go hand in hand, contributing to an inclusive and high employment economy. So if you look at the facts, the other report which comes from European Union 2019, which is the latest report, it says the IP intensive industries in EU are responsible for almost 45% of the economic output and generate 30% of the jobs. Similarly, if you look at the second point, it talks about how much it contributes to the British GDP and how much jobs the IP intensive industry creates. There is another report from Korea because as far as the facts and figures are concerned, a lot of applications have been filed in Korea as well. So if you look at the report, it is slightly old, which is 2015 that Korea came up with. It also mentions that IP intensive industries constitute 43.1% of the GDP, employed over 6 million people, and responsible for close to 80% of R&D investment in Korea. So all these facts and figures are important, or you can decipher or conclude something that IP intensive industries is the it constitutes an important part of GDP of a particular country. And that is why a lot of countries are moving towards innovation or technology driven economy rather than manufacturing or production. If you look at, right, if you look at this graph is particularly regarding China. Okay, so if you look at this orange one, so their investment in R&D as far as, or their investment in service driven industry, or their investment in IP intensive industry is increasing, whereas their investment in production or construction is decreasing, because they know the next thing or the important thing that will help them to boost their economy is intellectual property. Apart from intellectual property, yes, information technology also plays a very relevant role, but IP is again something that is the core of boosting your economy. Now, this is an interesting observation which was made by WIPO in Global Innovation Index. Again, WIPO comes up with ranking of different economies. And in the year 2019, they came up with this report. And this report interestingly talks about that how there is a shift of R&D from high-end economies to middle-income economies and lower-income economies. So what this is trying to say that earlier, most of the R&D contribution came from high-income economies. Okay, for instance, ये जो आपके European Union के countries हो गए, Switzerland, Sweden, Australia, etc., etc. So these countries used to contribute most to the global R&D. So if you look at the fact in the year 1996, the high-income economies accounted for 87% of global R&D. Okay, whereas in the year 2017, they only represent 64%. Why? Because the global share of R&D as far as upper middle income economies, notably China, and other countries, including India, have increased. Okay, so even the lower income economies or upper middle income economies, China and India, we are contributing a lot in R&D. And I think India is making a lot of progress as far as R&D and innovation in technology is concerned since the National IP Policy 2016 that came into picture. Apart from that, India has made a lot of reforms in their legislation to keep pace with international treaties and to become global economy as far as these rankings are concerned. Okay. Now look at this graph. This graph also talks about that how China has filed most of the patent application because it affects the contribution in GDP. It affects your economy. So it has filed more than what has been filed by US and Japan. Now let's see where does India stand as far as the ranking is concerned. Okay, so this is the ranking which comes from US Chamber of Commerce Global Innovation Policy. So India stands at 40th place out of 53 economies that were cross-analyzed by the report and on various indicators. Indicators includes a lot of things like IP performance, R&D, universities' contribution in R&D, information technology, ease of listening, etc. So these are the several indicators on which the performance of the economies is assessed, and then they are cross-analyzed, and accordingly they are scored on different indicators and a ranking is released. Similarly, as per Global Innovation Index 2019, India stands at 52nd, okay, out of around 127 economies that were ranked by this report. So if you see, there's a drastic change from 2015 to 2019. If you look at this chart, 2015, India was at 51st rank, but then in the year 2019, it stands at 52. Now look at this graph of India filing the patent application or trademark or industrial design application. So accordingly, here as well, if you look at the increase in patent application or increase in trademark, and consequently, there's an increase in contribution in GDP. So filing is basically about how protective you are about intellectual property rights. And it includes the filing by nationals of other countries as well. Okay, it is not like that only Indians are filing in India and then the GDP will rise. If the nationals of other countries are also filing in India, that is also included in this graph. Okay, and hence the GDP's contribution of IP in GDP is increasing. Okay, these are other, you can say, facts and figures or information regarding where does India stand. So India, as far as the report is concerned, it remains second among the middle income economies in the quality of innovation. So globally, it may not be doing really well, but as far as the middle income economies are concerned, of which India is a part, it stands second. So Central Asia, Asia, India is doing okay, but globally, it may not be doing that good, but it will take time to come up with that level. However, it maintains its top ranks in the number of important indicators such as productivity, growth, and export of services related to information and communication. It also contributes a lot to R&D expenditures. Now, there are other reports like United Nations Conference on Trade and Development, where it was said that India is the third most favorable investment destination for forest investment after US and China. This is an important part because foreign direct investment has a very intricate relationship with IP enforcement. So a lot of reports say that if you have a very strong IP regime, then it is more likely that you will have more foreign direct investment. Because if a company from different national is going to invest in your company, they would want their rights to be protected in your country. So if you have a good intellectual property, if you respect intellectual property, or if you protect the rights of foreign nationals effectively, or as much as you protect your national rights, then it is more likely that FDI will flow. And if FDI flows, then again it contributes a lot to the GDP of a country. So you see the link between the cycle, that goes to actually impact the GDP of a particular country. India is also ranked in the World Bank's Ease of Doing Business Index, which it has improved from 130 in 2006 to 100 in the year 2017. And it all has become possible because of a lot of efforts that government has taken as far as our motto is concerned, Make in India. That is something related to economy, Startup India, or the National Policy 2016, Ease of Doing Business, or the easy administrative procedure that Government of India has suggested. So as far as SMEs are concerned, there is a possibility that you can get your trademark filing fee or filing fee of any kind of IP waived off or decreased as per the proposal given by the Government of India. I think this is pretty much about the economic status or economic aspect of intellectual property right, and where does India stand. If you have any question, please go ahead. Or Krishnam, if you wish to add anything.
Thank you, Mr. Aru. I'm already answering some questions on the chat box. So if there is any question students have, they can ask you on the call. Thank you.
Okay.
Ashmika, I guess you had a question for Charu ma'am. Please go ahead.
Yes. Very good evening, ma'am. Very good evening, sir. So this is Ashmika. Ma'am, I wanted to ask you about the research areas or the some loopholes that are still existing in the IP laws or the legislations, which you feel that they are need to be addressed by the government. So I wanted you to put light on it.
Okay. See, Ashmika, there are plenty. Or what I would say that it is very difficult to keep pace with the advancement that is going on. So for instance, Krishnan talked about artificial intelligence, right?
Yes.
We have not amended our legislation in line with the latest developments that are happening because it will take time. You need to understand whether a particular creation or an innovation fulfills the jurisprudential aspect of IP or not. Okay, because whenever you come up with a legislation, you have a particular objective. Okay, that objective is basically the jurisprudential part of a particular legislation. So you have to understand whether a particular new creation or innovation, whether it fulfills the requirement of an existing legislation or not. So if it does not, then it becomes very difficult to protect that particular innovation unless you make amendments in your law. But there are a lot of things that I would say exist in the legislation which needs amendments. Say, for example, copyright law is concerned. Okay, so in copyright law, I see a lot of scope for interpretation. Now, whether you take interpretation as a loophole or not, or you say क्योंकि इसको बहुत ज़्यादा interpretation करना पड़ रहा है, इसलिए maybe the law is not clear. Okay, for instance, cinematographic film does not require originality as per the copyright legislation. The word originality is missing from the requirement of a cinematographic film to be copyrighted. Okay, so a lot of people interpreted that maybe intention of the legislature was not to include originality in cinematographic film, or a lot of people interpret that no, originality is required in a cinematographic film even if it is not mentioned in the law. Okay, A lot of issues exist as far as licensing is concerned. Okay, a lot, for instance, royalty sharing. Okay, so not everything is given under the legislation. Now, if I talk about trademark, even trademark has a lot of issues. For instance, these new non-conventional form of trademarks like touch marks. Okay, uh, or smell mark. So as far as Indian law is concerned, the definition of mark does not include touch mark or feel marks. Okay, so whether the requirement of rules are being fulfilled is a question that is to be answered. So there are a lot of issues that exist in the IPR legislation. There's another one thing that I wish to highlight here is that I see a lot of gap, or I see a lot of difference in understanding of law as far as the registration authority is concerned and the law is concerned. So when I read the legislation and when I look at the registrations, I feel that this registration should not have been granted because law says something else. Okay. And then when the matter goes to court, court looks at the law. So a lot of time it happens that a registration that was granted, court says that this registration should not have been granted. Okay. So that gap or that misinterpretation or that confusion exists a lot of times, not only in trademark, but also in patents as well, or in designs as well. Okay. So there are a lot of things to talk about it. Maybe you can we can talk about it offline, because it will take another hour to discuss. Yes.
Sure, ma'am. Sure.
Okay.
Thank you so